Your child is already separating and you gave him the funds and you didn't know any of this. And now it's all a big mess. So what can you do? Unfortunately, the answer is really not much. If your child and her ex manage to agree to the terms of a separation agreement, that agreement can protect the funds you gave your child as her excluded property. Sometimes, even when there's no evidence, people are ethical and will not take advantage of the situation. But sadly, that's not always the case. If the matter goes to court, you can be a witness for your child and give the court information about the circumstances under which you provided him the funds. Your testimony may be evidence the judge needs to find that the property is excluded. On the other hand, the judge will know that you want the money to go to your child and will take that into account in weighing your evidence. It was determined that a judge must look at all of the circumstances of the case, and that includes direct evidence, which would be things like documents, and circumstantial evidence. And the judge will also consider evidence that arises after the funds have been provided, but will do so critically. So it's not uncommon that when the funds are provided, the child and the child's ex have a completely different recollection of the circumstances in which those funds were provided. Maybe the child says, no, it was a gift just to me. Maybe the ex says, no, it was a gift to both of us. And so if the parent comes along and says, well, definitely it was a gift to my child, the judge will look at that, but will look at it quite critically because the judges are aware that over time, stories can change. So lastly, under certain circumstances, you can become a party to the matter and you can hire your own lawyer to protect your own interests. Maybe you're claiming that it was always understood that you would keep your 1% interest in the property, or maybe you have a trust claim to make. These remedies are not for your child, but they're for you to retain your own assets. The short answer is the best solution is to never get to this stage.